Hello, everyone. I hope you're having a great day today. We have a couple updates on the court case with John Karony and SafeMoon. This first video is going to be focusing on what the government has filed in their paperwork. I will have a separate video that goes over the details in the document that's filed in regards to John Karony's side. So to start with here, this post coming from DeFiStella.eth is where I discovered the document information for the day, but they did give proper credit. It actually looks like it came first from this account at live for Ford. So we're going to go ahead and reference this and go through the set of documents. So right here, we can see that it says, Dear Judge Committee, the government writes to respectfully request that the attached proposed stipulation concerning discovery materials be so ordered by the court. Certain discovery materials that the government intends to produce to the defendant will contain personal identifying information for individual and other sensitive information. The enclosed proposed stipulation will minimize the risk that sensitive identifying material will be disclosed to individuals other than the defendant, his counsel, and their legal staff. The defendant has consented to entry of the enclosed proposed order. Accordingly, the government respectfully requests, with the consent of the defendant Braden John Karony, that the court enter the enclosed proposed protective order. Respectfully submitted, Breon Peace, United States Attorney. Going on, it is hereby stipulated and agreed by the undersigned attorneys and ordered by the court pursuant to Federal Rule of Criminal Procedure 16D that, number 1, all material and information disclosed or produced pursuant to Rule 16 of the Federal Rules of Criminal Procedure pursuant to the Code and or pursuant to Brady v. Maryland and Giglio v. United States, to the defendant, Braden John Karony, the defendant, and the defendant's counsel, defense counsel, by the government in the above captioned case hereinafter, the discovery materials shall be governed by the protective order. Discovery materials, however designated, and any and all copies, notes, transcripts, or documents derived from the discovery materials may be used by the defendant, defense counsel, and defense staff, which is defined as non-lawyer staff employed or contracted by defense counsel, as well as potential witnesses and their counsel, expert witnesses, investigators, and interpreters retained by defense counsel, only for the purposes of defending against the charges in the above captioned case, including, but not limited to, preparation for trial and any sentencing appeal or collateral attack, which was commenced within a year of the exhaustion of the defense's appellate rights involving the charges in the above captioned case. Except as otherwise provided in the protective order, any and all discovery materials disclosed or produced to the defendant and or defense counsel by the government, and any copies, notes, transcripts, or documents derived from the discovery materials shall not be further disclosed or disseminated by the defendant, defense counsel, or defense staff to or with any individual, organizations, or other entities, except as expressly authorized below. Defense counsel or defense staff may show discovery materials to a prospective trial or hearing witness and or a witness's counsel only in the presence of defense counsel or defense staff, whether in person or virtual. Prior to showing such materials with any witness or witness's counsel, defense counsel must provide a copy of this protective order and advise the witness and or a witness's counsel of the terms of this protective order in writing, and thereafter obtain the express agreement from the witness and or witness's counsel to be bound by the terms of this order is in writing. For all non-expert witnesses, a witness and or witness's counsel shall not be permitted to retain or otherwise create copies of any discovery materials shown by defense counsel or defense staff pursuant this paragraph. None of the discovery materials, nor any copies, notes, transcripts, or documents derived from the discovery materials shall be disseminated to or discussed with the media in any form. Nothing in this protective order prohibits the media from obtaining copies of any items that become public exhibits at any conference, hearing, trial, or other proceeding. If the defendant obtains substitute counsel, the defendant, defense staff, or defense counsel will not transfer any portion of the discovery materials or any copies, notes, transcripts, or documents derived from the discovery materials, unless and until such counsel becomes counsel of record, has been provided a copy of this protective order, signs Attachment A to this protective order, and provides a signed copy of Attachment A to the government. Once substitute counsel has provided a signed copy of Attachment A to the government, and following defense counsel's withdrawal from the above captioned case, substitute counsel shall assume defense counsel's responsibilities under the protective order. The defendant may review discovery materials specifically identified by the government as sensitive discovery material. The sensitive discovery material only in the presence of defense counsel or defense staff, whether in person or virtual. Defendant is prohibited from having possession, custody, or control of the sensitive discovery material and any and all copies, notes, transcripts, or documents derived from the sensitive discovery material. The defendant, defense counsel, and defense staff shall not obtain or create any copies of the sensitive discovery material for disclosure or dissemination to any person other than the defense counsel and defense staff. If defense counsel chooses to share the sensitive discovery material with the defendant, a witness and/or a witness's counsel, that sensitive discovery material must be shared in the presence of defense counsel or defense staff, whether in person or virtual, and is subject to the same requirements set out in paragraph 4, except that a witness and/or a witness's counsel, including expert witnesses, shall not be permitted to retain or otherwise create copies of any sensitive discovery materials shown by defense counsel or defense staff pursuant to this paragraph. All discovery material specifically identified by the government as material designated for attorney's eyes only, the attorney's eyes only material, shall be treated as if it had been designated as sensitive discovery material with the additional limitations discussed in paragraphs 10 and 11 below. Attorney's eyes only material may be reviewed only by defense counsel and defense staff as defined in paragraphs 1 and 2 above, respectively, and only if such defense counsel and defense staff are citizens of the United States. Attorney's eyes only material may not be disseminated to or reviewed by any other person, including the defendant. Attorney's eyes only material may be shared with the defendant under the constraints applicable to sensitive discovery materials 2 weeks before trial unless the government shows good cause why it should not be shared. If the government and defense counsel are not able to reach agreement on the sharing of attorney's eyes only materials, the government and defense counsel may seek intervention from the court on an ex parte basis or otherwise. Attorney's eyes only material must be maintained on a computer or computers within the Office of Defense Counsel and may not be transported or transmitted from those computers without order of this court. Any documents, materials, or information may be designated sensitive discovery material only upon a good faith belief by the government or defense counsel as it pertains to reciprocal discovery that such materials contain information obtained from the private homes, devices, accounts, communications platforms of any third party, identifying information for any potential witness, victim, or individual not a party to the litigation, sensitive information of a victim or of a witness, law enforcement sensitive information, information that could implicate the safety of others, information that could impede an ongoing law enforcement investigation, and or any other information that the government deems in need of heightened protection under this protective order. If the government and defense counsel do not agree that certain material should be designated as sensitive discovery material, the defendant may provide notice to the government and a reasoned explanation regarding why the defendant does not believe the materials require treatment as sensitive discovery material. To the extent the parties do not agree, either party, upon providing notice of the intent to make such an application, may apply to the court to determine whether the material should be treated as sensitive discovery material. Nothing in this paragraph shall preclude defense counsel, after consultation with the government, from making an application to the court on an ex parte basis or otherwise in connection with the government's designation. The defendant shall treat the material as sensitive discovery material pending any determination by the court. Any documents, materials, or information may be designated attorney's eyes only material only upon a good faith belief by the government that designation as sensitive discovery material provides insufficient protection to such materials. If the government and defense counsel do not agree that certain materials should be designated as attorney's eyes only, defense counsel may provide notice to the government and a reasoned explanation regarding why defense's counsel does not believe the materials require treatment as attorney's eyes only material. To the extent that parties do not agree, the government may make an application to the court and seek to establish good cause regarding why the material should be treated as attorney's eyes only material. Defense counsel shall treat the material as attorney's eyes only material pending any determination by the court. Any documents, materials, or information determined to be sensitive discovery material or attorney's eyes only material may be so designated by stamping the legend sensitive or sensitive attorney's eyes only on the document, appending to the Bates numbering STM for sensitive discovery material or AEO for attorney's eyes only material, or by otherwise indicating the appropriate designation prior to production of the material or information. While each page of a sensitive document and its attachments may be marked, it shall be assumed that a sensitive designation on the first page of a document indicates the same sensitive designation for the entire document and its attachments unless otherwise noted. Where electronic files or documents are produced in a format that make stamping impractical, such files and documents may be designated by appending to the media on which such a file or documents are produced, file name, or to the electronic folder in which the file is located, information indicating that the file contains sensitive or sensitive attorney's eyes only material. The defendant and defense counsel will return to the government the discovery materials, the sensitive discovery materials, and the attorney's eyes only materials, and all copies thereof, whether in the possession of the defendant, defense counsel, defense staff, or any other signatory to attachment A to this protective order, when the defendant concludes all efforts to defend against the charges in the above captioned case and any superseding indictment, including but not limiting to preparing for trial and any sentencing appeal or collateral attack which was commenced within a year of the exhaustion of the defendant's appellate rights involving the charges in the above captioned case. Nothing in this protective order shall preclude the government or the defendant from seeking a further order pursuant to Rule 16D as to particular items of the discovery materials. Nothing in this protective order in any way releases counsel for the government or defense counsel from the obligations of the free press fair trial directives of Local Rule 23.1 of the Local Criminal Rules of the Eastern District of New York. In the event the terms of this protective order are violated, defense counsel or the government shall advise the court in opposing counsel immediately of the nature and circumstances of such violation. This court shall retain jurisdiction over all persons subject to this order to the extent necessary to enforce any obligations arising hereunder or to impose sanctions for any contempt thereof. And it's dated here 2022. It says right there, that's interesting. Brooklyn, New York. So ordered the Honorable Eric Committee, United States District Judge, Eastern District of New York. I wonder why it's dated saying that that's 2022. It says filed up at the top for today's date, November 27th, 2023. Okay, and that does it for this document. I will have a separate video that goes over what the defense's side is saying with John Karony. So keep an eye out with that. It is a shorter document, but I don't want these videos to be too crazy long and for you guys to have the access to each individual set of material as well. I think that's also going to be important. Trying to make sure that I label everything appropriately. But yeah, I don't want to drag on this video any longer. Maybe in future instances, if there's a lot of short bits of information, I might still put it in one video. We'll see how things go. But yeah, this was pretty long. Let me know what you guys think about this down in the comments below. Thank you so much to my Patreon supporters. A double shout out thank you to We Love Victor Vegas and XMoon Oz for being higher level patrons. Thank you to my YouTube members for your support as well. God bless, and we'll see you in the next episode.